The averments in the plaint are elaborate. Commensurate to the detailed plaint, the written statement is equally elaborate. To wit, the plaint runs into 8 pages, and the written statement is 16 pages long. The resultant consequence is that, in the trial, much oral evidence is brought on record, resulting in a lengthy judgment by the trial court. The judgment of the appellate bench is equally lengthy, even though the core issue for consideration could have been captured in a nutshell by the appellate bench. A judgment should be coherent, systematic, and logically organized. It should enable the reader to trace the facts to a logical conclusion on the basis of legal principles. Lately, this court has been experiencing meandering pleadings irrespective of the nature of the dispute. We are reminded of Abraham Lincoln's ode to a lawyer friend. He can compress the most words into the smallest ideas of any man I ever met. Such lengthy pleadings would even upset Polonius from Shakespeare's Hamlet. Every word that is not a help is a hindrance because it distracts. A reader who realizes that a brief is wordy will skim it. One who finds a brief terse and concise will read every word. The parties to a suit ought not to compel the court to exercise its jurisdiction under Order 6 Rule 16 of the Code of Civil Procedure, 1908, and strike out unnecessary or frivolous pleadings. The effort of pleading and evidence should be to be concise to the cause and must not confuse the cause. The lengthy pleadings and avoidable evidence are well within the scrutiny of trial courts, and, at the right stage, must be regulated within 4 corners of the law. Such an approach by trial courts would, like a stitch in time, save 9. Long and drawn-out pleadings will run the risk of having a cascading effect on the appellate and revisional courts. Meandering pleadings will land up with laden weight in SLPs, making the narrative difficult. The time has come for courts to invoke the jurisdiction under Order 6 Rule 16 and make litigation workable. Courts are also confronted with AI-generated or computer-generated statements. While technology is useful in enhancing efficiency and efficacy, the platched pleadings will disorient the cause in a case. It is time that the approach to pleadings is reinvented and reintroduced to be brief and precise. Having remarked on the need for brevity, we have a task on hand to deliver a brief judgment.